Hi, everyone. Welcome. I'm Katy Glenn Bass. I am the research director at the Knight First Amendment Institute at Columbia University. And I am here with Jamal Greene, who is the Dwight Professor of Law at Columbia Law School, where he's taught constitutional law, comparative constitutional law, the law of the political process, the First Amendment, and American federal courts. He's also a co-chair of the Facebook Oversight Board, which is having quite a busy week. And he's a former senior visiting research scholar at the Knight Institute, where I had the pleasure of working with him and where he led a project curating a series of essays called Free Speech Futures. His new book is How Rights Went Wrong, and it's well worth buying. We're going to talk about that for the duration of the event. And with that, I'd like to welcome Jamal. Thank you for being here. And please go ahead and introduce us to your book.
Thank you, Katy, and thank you to everyone who is on this call. I know it's hard to do these things on Zoom sometimes. I'm going to say just a few words about the book because I want to spend most of the time with Katy's questions and with your questions. But for those of you not familiar with the argument, it's a criticism, I think that's fair to say, a criticism of the way in which Americans in general and courts and American courts and other legal decision makers in particular approach rights disputes. And if I had to sort of sum up the problem that I'm trying to address in brief, I would say I'm interested in the problem of maintaining a culture of rights under conditions of radical pluralism, under conditions in which we all disagree with one another. And the reason we disagree with one another is not because some of us are right about the things that we disagree about, and some of us are wrong, that some of us are angels and some of us are devils, but because we're different from one another, and different people have different values and commitments, and trying to figure out how to integrate that background reality into a system in which often courts make binding legal decisions about our rights is a challenge. It's a challenge not just in the US, it's a challenge around the world. The book brings in a number of comparative examples to try to show a range of ways of approaching that basic problem of diversity. One of the things that law professors like to do when they teach cases is to ask about the facts. And what I mean by that, I'm using facts in a loose sense as what are the legally relevant pieces of information about this case? And I think that that question is an entry point to the to trying to kind of explore the problem that I think the book identifies, which are we focus on the wrong kinds of information about rights disputes. We tend to focus on what one could call interpretive facts about rights disputes. What is the constitutional provision at issue? What does that provision mean? What right does it protect? Who holds that right? Those kinds of questions, which are ultimately, I argue in the book, are rather abstract legalistic questions, as opposed to focusing on a different set of facts. You can call them kind of nuts and bolts facts. What are the interests at stake in this dispute? Who's acting here? Who's being burdened? How much are they being burdened? Why? Is it justified? Are there alternatives? Now I'm being a little bit abstract, right? So I'll try to contextualize it with a case that will be familiar to a lot of people who are interested in the work of the Knight Institute, but that I don't talk about very much in the book, which is Citizens United, which is a case in which this company, Citizens United, it's a corporation that is set up in order to engage in mostly conservative political advocacy. They put out a movie about Hillary Clinton. It's a hit piece in the days leading up to the primary election, or they would like to put out a movie in the days leading up to the primary election in 2008 when she's running for president. And they run up against campaign finance law that says that you're not allowed to use your corporate treasury funds to fund electioneering just before an election. Now, I've already given sort of more facts than the typical public conversation around a case like Citizens United tends to reveal. It tends to be framed, and it indeed was framed in the Supreme Court's opinion itself, as a case about the meaning of free speech and who holds it. Do corporations have free speech rights? Is money speech, right? Those kinds of questions are ones that we're all familiar with as being associated with the case. Those are the interpretive facts of a case like Citizens United. Those are the facts that someone who is what I pejoratively call in the book a rightsist would ask about Citizens United. Who holds the right here? Because once we figure out, we know that free speech is supposed to be close to absolute. First Amendment says Congress shall make no law. It's supposed to be really super, super strong right. And so once you say someone holds a speech right, then that's mostly the end of the case. And that's what the court basically held in Citizens United. It said corporations have speech rights. There's a tradition of corporations having speech rights. This is speech about political content. So those are especially strong speech rights. Therefore, the strictest of scrutiny applies, and this law can't possibly satisfy. Strict scrutiny, QED, end of case. And then there's some debate about, well, what about originalism? What would the framers have thought about whether there's a free speech right in this kind of case? When what the book tries to urge is, in response to a case like this, to think about a different set of facts, which are the more kind of nuts and bolts questions in a case like this. What we should want to know in a case like Citizens United is money speech, which is not a useful question. And is free speech at issue in Citizens United? Because of course it is. And it's not, do corporations have speech rights? Because they do for some purposes, but not for others. They are, well, what's going on here? And how far does it go, right? So what are some of the questions the court should have asked in a case like Citizens United? Well, one question would be, what is the government trying to accomplish? So the government was trying to equalize or provide some substantial equality between the access to the political process for citizens. They thought that corporate money was drowning out the speech of other people, of ordinary citizens. Well, what evidence is there of that? Well, let's see it. Let's see if that's actually happening. Let's see if corporations are actually behaving in this way. Citizens United, and that question is just not even asked. It's asked in a very conclusory way in Citizens United. Citizens United is actually not prevented from speaking in Citizens United. It was only prevented from speaking in a particular way. So the particular way being using its corporate treasury funds. They could have set up a separate political action committee and spoken in that way. Is that burdensome? How burdensome is it? Is it really much more difficult for corporations to set up a separate political action committee? That question's not asked in Citizens United, even though I think in some ways that's the central question of the case, is how burdensome is it for them to set up this separate political action committee? What kind of corporation is Citizens United? Is it closely held? Is it traded on the New York Stock Exchange? Is it an ideological corporation? Does it sell widgets? Does it sell cars? Shouldn't we care about those questions when we're asking about how far the free speech rights of this entity might go? The court doesn't care, it just flattens all of that into corporation, free speech rights. Well, we should care about those things. Should we care that this was a movie? Should we care that it was a video on demand movie, so that people who wanted to watch this movie about Hillary Clinton had to ask for it, rather than being held captive to a television ad, which is what the campaign finance laws were mostly focused on? Yeah, we should probably care about that. Not asked, not of interest to the court, that question. So you kind of see where I'm getting, which is to say, focusing on those kinds of questions gets at the genuine questions of justice in a case like Citizens United, because there were interests on both sides that are of constitutional dimension, right? The case is not just a case about the free speech rights of Citizens United, it's also about citizens getting together and passing laws, which is something that we protect under our Constitution, and passing laws in a particular way that impose certain kinds of burdens, but not other kinds of burdens. Well, we have to get into that in order to resolve a case like Citizens United. And if we ask those kinds of questions, we actually get a little bit closer, and I can say this through personal biography, a little bit closer to consensus. Because if you ask me, is Citizens United rightly decided? Well, if Citizens United is if the proposition that Citizens United stands for is that corporations have unlimited speech rights in political elections, then I'm going to say Citizens United is wrongly decided, because there are circumstances under which I think those speech rights should be limited. But if you ask me, should an ideological corporation be able to put out a video on demand movie about a political candidate just before the election? And if you tell me further that requiring them to do that through a separate political action committee would be burdensome to them in some meaningful way, well, I'm starting to think that Citizens United has a pretty good case. And so now I can have common cause with someone who has different instincts about corporate speech rights writ large, right? We can start asking questions about facts rather than questions about values, because our values are different from one another. The point of the book is to say that this is what courts should be doing. This is the job of a court, is to resolve disputes. Those disputes require attention to the facts of the dispute, not attention to whose values should win and whose values should lose. That is a fool's errand. And it's destructive, and it's destructive in at least three ways that I'll just briefly outline, and then let Katy have at me. First way is that it does separate the question of rights from the question of justice. We tend to think that constitutional disputes are about the legal architecture that we build around those disputes, as if Citizens United, for example, is a case about strict scrutiny, or is a case about the meaning of the First Amendment's text. Well, no, it is a case about a corporation that wants to put out a political ad. That's what it's a case about. And a government that's passed a law that seems to restrict its ability to do so. That's what the case is about. And those are the kinds of questions we should be asking about the case. Those are questions that point to justice, not questions of interpretive method or questions about legal precedents. Those aren't justice questions, those are legal questions. Second problem is that it makes it very difficult to appreciate situations in which there are rights on both sides of a conflict. And it's very, very rare, including in the political speech area, but also many other places. I focus on abortion rights, for example, in the book very heavily in talking about this, also race-based affirmative action, where there are rights all over the place, right? So there's a litigant who's claiming rights. There might be someone else who's being protected by the law who's claiming rights. The people who pass the law might be claiming rights of their own to democratic participation, and having the outcome of that democratic participation be the law and not being overridden by judges. There are lots of rights on all sides of a conflict. Courts are not, in the US, don't frequently acknowledge that. And it can lead to distortions, because we often, the courts see their job as figuring out who holds the right, as opposed to conceding that there are rights on all sides, that lead to courts having to mediate between those rights in some way. I use the term mediation quite a lot in the book, because I think that's closer to what judges should be doing, as opposed to declaring who has rights and who isn't, being a rightsist, discriminating between different rights. And then the third point, and I'll close at this, is it exacerbates polarization. And the way in which I think it does that is that we end up thinking that the way in which we resolve rights disputes is by assigning constitutional value to one side of the dispute or the other. That's very high stakes for a political dispute, to say one of these litigants is favored by the Constitution and the other is not, and can lead to kind of all-out warfare over ordinary political disputes that should be resolved in ways that that communicate the value in the position of lots of sides of a large number of political disputes that we have. Maybe not all of them, maybe not Jim Crow, and can get into that, right? But the mine run of our political disputes get turned into constitutional rights disputes that adopt this kind of Manichaean polarizing posture of one side being absolutely right and the other side being absolutely wrong. And we're not going to solve polarization problems through judges, but we can stop making them worse. And that's the part of the point of the book.
That's great. Thank you, Jamal. So for everyone in the audience, thank you for joining us and for being here. You can submit questions throughout our conversation in the Q&A box. I'll keep an eye on it. Please just mention your name and I'll work them in as we go. So I had just a few observations about the book and the argument you're making, and then I have a couple of big questions for you, and then some more about the way your approach would change the way courts tend to deal with First Amendment claims, since that is of particular interest to me. But to begin with, one thing I was struck by in this book is that this approach to rights that you're advocating for would, by most people in the US, be seen as fairly radical. But if you're looking at this from many countries outside the US, it's seen as completely mundane. Your book is a good reminder to me of how exceptional the US legal system is in the value neutral sense of that word, that we just do things very differently than a lot of other countries. Not only is there another way to approach rights disputes, many, even most other countries already do it that way. And I think one thing I really appreciated is you work in comparative examples, many from constitutional courts in other countries, showing the way that they would approach the same problem, where you have an example where there's a US case about it, and then an example where there's a case from another country. And that compare and contrast just really illuminates your points very well. So I thought that was well done. Another thing I was struck by when I read this is how humane the approach is that you're advocating. So this sort of context-specific, context-heavy approach, looking at what is right in this case, what is right for this set of facts. The more fact-specific you get in terms of your analysis, the more you might have issues with forming coherent precedent or extracting broader principles to apply to future cases. But at the same time, it's an approach that moves away from looking at disputes as sort of dry legal hypotheticals that are no different than something you'd see on a law exam, and looking at them instead as issues that are going to have a real impact, decisions that are going to have a real impact on real people's lives and real people's ability to thrive. You also take a very human view of judges, and if we have time, I want to come back to this. You take the time in a lot of the cases that you discuss in this book, you look at the background and the experiences of the individual judge who made the decision in the case. And I thought that was interesting, and I want to get into why you chose to do that. So I think the third thing is what you touched on earlier, the sort of the different relationship between rights and justice that your book lays out. And I guess that leads me to my first question, which is a very large one, but one that I think your book addresses, which is, what is the vision of justice that you're advancing here? How do you think Americans should think about doing justice or getting justice?
So I don't think the book has an overarching vision of justice, except in one sense, which is that the book is small d democratic, not in the sense of sort of cacophonous democracy, but in the sense that of democracy as a way of resolving pluralism in peaceful ways. That we're all very different from one another. We have to live together. We're forced to live together, and we should create institutions that enable that to happen in effective ways and in nonviolent ways. And so that is a moral political vision. And so I can't say that it's not, right? But the way in which it's committed to doing that is quite susceptible to a number of different outcomes. So there's a way of reading this book, because I use the term justice, right, to say that well, there's the Constitution on one side and the law on one side. He wants to get us to justice, and that's in some ways, that sounds lawless, or something outside of or external to law. But what I really mean is that the Constitution itself embodies it has political moral values embedded in it. We disagree about those political moral values. So we all have different views about what they specify, in what those values specify in particular cases. What I'm trying to urge in the book is to talk about those political moral values that are embedded in the Constitution in ways that that actually track the values rather than talking about them in some other way. And what do I mean by that? And I'll just to go back to the example that I that I started with, the Citizens United, is when I might have a different conception of a different view of what a just outcome in Citizens United is than you do, Katy. I don't know, Katy. But the kinds of questions that speak to the justice of Citizens United have to do with the nature of the burden on the company and its principles, and it has to do with how I feel about what the government is trying to accomplish. What objectives is the government trying to achieve? How is it trying to achieve those objectives? Is it trying to do so in ways that burden other things that we think are valuable or that I think are valuable? Those are the kinds of, and if I know the answers to those questions, I can give an assessment of the just outcome in a case like Citizens United. As can someone else who disagrees with me about what the just outcome is. They're going to ask the same set of questions, and they may reach a different judgment. Asking, what does Congress shall make no law mean? That has nothing to do with the justice of the case, or very little to do with the justice of the case. It has a lot to do with interpreting a text. Right, but that's a question that lawyers ask, and when it comes to these rights cases, the text is totally underdetermined. It doesn't tell us much about justice, and so what I'm trying to get at is to direct people direct judges, direct citizens as well, into conversations about rights that are in fact about the justice that the Constitution embeds. If we were in a different constitutional system, one that had no rights at all, this book would look very different, right? So I'm not suggesting that that anything extra constitutional. I'm suggesting a way of implementing the Constitution. And I'll just note, and this is just back to your comparative point, right? The U.S. Constitution is really short, and it's really not very specific when it comes to most of the rights conflicts that we argue about. You don't get very far resolving most modern rights conflicts by simply stating something in the Constitution, right? You've got to go beyond that, and interpretation runs out long before we get to the specifics. And if we just go back to interpretation rather than talking about the specifics, we get away from justice. And justice is, I think we all think that justice is embedded into the constitutional rights provisions in the U.S. Constitution.
So that plays well into what I'm also thinking about now, which is your discussion of the San Antonio schools case, which is a case that has stuck with me since I was in law school in terms of really glaring indifference to actual human rights as recognized by the Constitution. So it's not the only time you reference positive rights or what the international human rights system would see as economic, social, and cultural rights, so rights that impose a positive obligation on the state to do something. But you bring them in here in terms of your analysis of how that case was decided in the United States, and then in a comparative case of how the Indian Supreme Court interpreted the right to education in India. And I was wondering if you could share a little of that here, because I think it's a very useful comparison. And I'm also wondering, I wondered at times during reading this, whether you are arguing that positive rights are already in the Constitution, that they're in that moral and political values that we all see as deep within the Constitution, or whether you're saying that we necessarily have to read in some positive rights in order to affect the rights that are already recognized by the Constitution, if that makes sense.
Sure. So let me say something about positive rights in general, and then I'll say something about the San Antonio case and the Indian comparison. So um, we tend to discriminate between positive and negative rights, and it actually goes back to this to the underdeterminacy of the constitutional language. The Constitution doesn't say anything about positive rights or negative rights. Um, and you know, if I ask you, an American lawyer, is there a right to education in the Constitution? Your U.S. legal training will tell you to think, well, San Antonio seemed to say no. And so there is no right to education in the Constitution. But of course, there is a right to education in the Constitution, and everyone agrees with that. There's a case called Meyer versus Nebraska, right, which says that you can't be denied the right to learn German, right? The government can't come in and stop you from getting an education. Now, why does basically every mainstream lawyer agree that the government can't stop you from getting an education, but disagree that the government doesn't have any obligation about whether the government has any obligations to make it possible or easier or facilitate your education? Well, the difference between those things is not a textual difference, right? The right that there's nothing, education's not mentioned in the Constitution, right? So what's the difference? It's just an interpretive thing, right? It's just that we've just decided not to interpret the Constitution to impose positive obligations in this particular area. It does impose positive obligations in other areas, right? So your right to a lawyer is not just your right not to have a lawyer taken away from you. It's a right to have a government provided lawyer if you're indigent. Your right to vote, right, requires the state to set up a voting apparatus and count your votes, right? Right. So we do sometimes impose positive obligations, but not as a matter of text, just as a matter of, well, we just interpret the Constitution in a particular way, right? And so what the book is trying the larger point of the book is, right, we can extrapolate beyond that, which is to say the Constitution's text just doesn't get us very far. And so we've got to ask questions about, well, when you talk about the right to education, the real questions are, well, how is your education being affected? How is it being impeded? What are the alternatives available? How burdensome is this? So San Antonio is a case where two neighborhoods in the same school district get different per pupil funding, vastly different per pupil funding, because per pupil funding is based on local property tax valuation, and the poor district has a small property tax base, and the rich district has a large one. So they've got, better books, and they've got better, less teacher turnover, and they've got a better school building, and they've got like air conditioning, and the other school is just in this dilapidated state. Even though it's public education in the same state and indeed in the same school district in San Antonio. And this goes to the Supreme Court in 5-4, it's challenged on equal protection grounds and basically on fundamental right to education grounds. And the court just can't, Lewis Powell writes this opinion where he just can't figure out the right legalism to apply to the case. Right? He's like, well, does strict scrutiny apply here? Well, only if we can say there's wealth discrimination, and there can't really be wealth discrimination. Do we even know if these kids are poor? Like, we know they live in a poor neighborhood. Do we know that they're poor? Well, no, we don't really know that. So it's not really discrimination on the basis of wealth. It's just geographic discrimination, and that's not strict scrutiny, right? And there can't be a fundamental right to education, because the same kinds of arguments that lead to that lead to fundamental rights to food and fundamental rights to housing and shelter. Of course, we can say the same thing about whether there's a right to food. Government can't take away your food, right? And so he says there must not be a right to education, because otherwise it would lead to all these other things. So rather than talk about this case, right, it lost in all of this talk about strict scrutiny and about fundamental rights is like, what's happening with these kids and why? And is there something that the government could do about this, and how burdensome would it be for the government to do something about this? Can it get them some air conditioning? Like, that's like we're making progress if we can say yes. And saying that there's a right to education doesn't tell you what that right entails, right? We got to ask questions about why the government make the decisions it did. Now, the Indian comparison is, India is a place where, and by the way, Lewis Powell was a sort of radical anti-communist, and he was heavily involved in the U.S. Chamber of Commerce, and And so his opinion is sort of dripping with like, we would be turning this into some kind of socialist state. The other gloss on, of course, San Antonio is that San Antonio is also a desegregation case, right? Because the form that segregation takes is private ordering, and Lewis Powell was opposed to the Brown the post-Brown desegregation order, and so he's preserving this form of resegregating schools. But the India case, so India doesn't even have a, at least at the time of this, the cases that I talk about, did not have a textual, judicially enforceable right to education in its constitution, but the court read it into the constitution because it was so obvious that there were things that the state should be doing but wasn't doing in respect to its schools. Now, India is, of course, a place where there's no way you can give like a high quality education to all of the children of India. It has the most children in the world, and the most illiterate children in the world, and the most poor children in the world, right? So, so that just radically different circumstances, and it's an example of ways in which the declaration of a right to education, what it ended up meaning is, well, there are future cases in which it's litigated and in which schools are required to have better infrastructure so they don't they don't end up being set on fire. And schools are required to give midday meals to students to encourage them to come to school. It doesn't mean we're going to like order the government to equalize all the schools, because that's impossible. And recognizing that impossibility is part of the case, right? Part of the case is to say, is this possible? And if it's not, of course, then you can't do anything about it. But if it is, and it's just money on the table, you should, there's a role for courts to play in requiring the government to take that money.
Great, thank you. So with that, I mean, with the Indian case, the way you describe it in the book also is that the Supreme Court in India in that case recognizes the right to education in a partial and not in an absolute sense. And then you go on to argue that if a US court were to do something like that, it would provide leverage to students, to teachers, to school boards to negotiate for more benefits in the educational context themselves, so that the court's ultimate intervention would be needed less. And I'm wondering if you can explain that argument a little more. So first of all, how would we go about recognizing partial rights in a US context? And then also, how does that partial right facilitate political fights over this that don't just wind up back in court when somebody is fighting over whether or not it's been fulfilled?
So partial rights, and this is my term, not yours, but it is a little bit glib, right? So what I mean, I don't mean to say that rights are halved or something. What I mean is that rights are, and I'll use the language of Robert Alexie, who has a great and complicated book called A Theory of Constitutional Rights, uses the term optimization. Right? Rights have to be optimized. They're not maximized. They can't be maximized because there are other rights, and those rights come into conflict. And there are also government institutions and values and commitments, and there's democracy built into what the government does. So you don't maximize, you optimize. You push the right as far as it can go in light of pushing other rights that are coming into conflict as far as they can go. And in doing so, you don't fail to recognize a right just because you can't recognize it absolutely, right? You take the right as far as the right can reasonably go. And sorry, let me try to hang this up. I'm getting calls. Sorry about that. So in the so what part of and you mentioned this point about leverage that I make, which is and I make this most acutely in the disparate impact context, right? Where and I've thought about this a lot in the disparate impact context, where people should ordinarily, as a first order matter, should work out conflicts through politics, right? They should negotiate about things. But if the court tells you, no, there's no circumstance under which you can ever raise a disparate impact claim, right? Even if there's a large and totally unexplained disparate racial impact on a marginalized group, if the state was aware of that impact, didn't care about it at all, chose a course of action that would produce that impact, because they were just indifferent to whether there would be that impact. You just have no constitutional claim whatsoever. Well, how are you going to participate in politics under those circumstances? Knowing that you have no leverage in politics under those circumstances. And that part of the role that courts play is to set some boundaries for how far politics can go, so that at some point a court can say, yeah, we do recognize disparate impact claims. That doesn't mean the person claiming the disparate impact is always going to win. And the case, Washington versus Davis, where the court rejects disparate impact discrimination as being constitutionally intelligible, the court seems to assume, for some reason, that all these claims are going to be successful. But you set some boundaries. You say, well, you got to give us a reason, or maybe there's going to be a burden shifting framework we put in place, as we do in the Title VII context, right? There are tools that courts have to say, well, you can get your foot in the door, and if you can get your foot in the door, well, now you can actually participate in politics within a more narrow frame, because we want the stakes of politics to not be life and death. We want the stakes of politics to be more narrow than that. How do you avoid going back to court? You don't necessarily, right? Courts exist for a reason. The point isn't to get rid of courts. It's to change the stakes of their opinions. So it's expensive to go to court. So first of all, you may not want to go to court if the court is not going to give you everything that you want and is only going to give you some of what you want. Maybe you should just negotiate about that rather than spending money on lawyers, right? So that's also that's part of the political moral vision of the book, is that most rights disputes are political disputes, and courts have a role to play in those, in setting the boundaries of political conversation. But their job is not to say, whose politics are right and whose politics are wrong.
Yeah, that is also what I took as like a sub argument in your book, is that some of these disputes that are currently fought in court, to the intellectual death, really don't necessarily belong in court at all, that they belong in front of a mediator, or they belong in some other institutional context, which I want to come back to in a moment, because I think you go back into history to the time of the founding, and you talk a lot about local institutions and the role that local institutions like legislatures, but also churches or community centers or just local centers of life, played at that point in negotiating rights and in resolving disputes in the community. And I'm wondering if you see, when I read that, I thought, it sounds like there's a lot of promise there, but then I think about what a lot of state legislatures are engaged in doing right now when it comes to things like rolling back voting rights and going after trans kids just for being trans and things like that. And it doesn't seem like that's the right place to put our hope for mediating rights in a more practical or humane way.
So yes, there's lots of reasons not to trust modern politics. We have and those of you in the audience who are lawyers will be familiar with Caroline Product's footnote 4 and with John Hart Ely's formulation of that footnote, which basically says the times that judges should be especially attentive to and be scrutinizing of the political process are when there are indicia of distrust of the political process. And he and Caroline Product's footnote 4 identify impacts on discrete and insular minorities and self-dealing as being the kind of main indicators of distrust, right? When the ins are keeping the outs on the outs, is when you should not trust them. I think that the general instinct that we should care more, that what we now call strict scrutiny should be tied to distrust is right. I think the idea that should be understood categorically rather than in the case itself is wrong, right? So that we should decide that, okay, I'm sorry about, I should know how to do this, but I can't. So you'll just tolerate that. it'll stop eventually. That we shouldn't necessarily understand those things categorically. So if it's the case that a legislature is behaving irrationally, part of the job of the court is to say you're behaving irrationally. If the legislature is burdening rights that we have good reason to think are important, like voting, well, that's a pretty good reason to push back on the legislature. Voting is super important, right? So it's not I'm not suggesting any kind of abdication in a situation in which legislatures are not trustworthy. But the ways in which legal decision makers should be evaluating what legislatures do is with attention to their purposes, the evidence associated with it. They're not going to get it right all the time, and they're certainly not going to get it right from my perspective necessarily, or from yours. But they'll be asking the questions that courts should be asking, right? This isn't just I think there's a way of reading the argument as being sort of naive and utopian, but it's not intended to be, in the sense that we're still going to disagree about lots and lots of things. And there are still going to be courts that don't do a good job, and courts that are motivated by their political instincts or political ideologies. But the point is that the conversation that courts are part of is a conversation that should get to that should actually be about, it shouldn't be legalized and abstracted away from the particular conflict. Second thing I'll say about this is that when I talk about sort of reinvigorating politics in political institutions, I don't just mean legislatures. And the reference to the founding, and there are lots of problems with the way in which the founding era understood politics. So I don't mean to valorize but only to say, I really talk about the founding in a defensive way, which is to say, look, if you think that the reason we have the rights culture we have is because of the founding, that's wrong. And I'm very confident that that's wrong. But when I say politics, we're engaged in politics right now in this conversation we're having, because we're trying to talk about things that we don't necessarily agree about, but talking about them, right? So politics is also political culture. And what I mean is that the rest of us, not just legislatures, but the rest of us who aren't judges, have a stake in negotiating and mediating our rights disputes. I don't mean by passing law, so that's one way we do it. But we also do it in ordinary conversation. We do it by participating in a democratic culture that leads to opinion formation. And I'm very wary of outsourcing that to people who have no democratic credentials and who are talking about political disputes in legalistic terms. I think that's a very unhealthy way to participate in democratic culture. So I mean, I have a what I think of as a rich conception of what politics means in this context.
I think that's a good point. And I don't, for the record, think that you are valorizing the founding in any sense. I think you've made a very good case in the book for why the founders or the founding era understood rights in a much more limited sense than what we have come to think of them. On the question of democratic culture, I'm going to work in an audience question here, because one thing that sort of hangs over this book and that you mentioned in your intro remarks is this deeply polarized political environment that we're in right now, where, as you say a couple of times in the book, the sides kind of hate each other. Like there's really very little sense of common ground. And there's a question from Jacob Shepard, and he asks, rights mediation often seems to require at least some level of intervention by non-judicial government actors to safeguard certain rights, and the West German abortion example being particularly salient. Then he says, in a radically pluralistic society in which the role and nature of government is fiercely contested, do we have the necessary environment for this approach? Or I guess I would also add to that, can we get to the necessary environment for that approach?
Well, I don't know, and I'm not. I'm an optimist in my personal life, but am I an optimist about our political fate? Not necessarily. So I don't know if we have the right environment to get there. I do know that what American law is doing is not helping. Or at least I'm pretty confident of that, that the way we frame rights disputes is not helping. The most developed German example in the book is about abortion rights. And this is a very good example of Jacob's question, right? And it takes us through from the early 1970s to today, the parallel universe happening in Germany when it comes to court involvement in abortion rights disputes, where the issue of abortion rights was more controversial in Germany in the early 1970s than it was in the US. You get Roe versus Wade here, you get a West German constitutional court case in 1975 there. And I won't get deep into the details here, but just to say that I make the argument that the way in which courts framed the rights had an effect on the political conversation around those rights in ways that were productive in Germany and destructive in the US. And we're still living with that, so that abortion rights are much less controversial in Germany than in the US today, and that has something to do with political compromises that are encouraged by the behavior of the court. Now, to say that was a road not taken and that road might have been possible is different from saying, well, right now what we should do is adopt the German approach, and then we'll solve abortion rights. The second of that is much more optimistic and something I'm not confident about. What the example means to show is, we tend to essentialize the US approach as if this is just the thing you do about rights. And I want to say that, no, that's not right. And in fact, some things that we think are just inevitable may not have been inevitable. And that there actually are ways in which what courts do and what other legal decision makers do about rights affects politics. So, and part of that is my own anxiety about, when you're a law professor, do courts matter? Right? That kind of question gets asked a lot. And, I try to show in a number of chapters, and that one in particular, that courts do matter. And that doesn't mean we know what to do about abortion, but it does mean that what we do matters to politics. And so do we have the tools we need to implement the recommendations in this book? Well, we have a lot of people in the world and in the legal world and in the political world who are in fact acting in good faith. I will put the U.S. Congress to one side, right? That's not. You can even put the U.S. Supreme Court to one side, and not to say that they aren't acting in good faith, right? But to say that we often focus a lot of our attention on the most high-profile actors, and there's a lot of research to show that the behavior of those high-profile actors is not representative of the American people in lots of ways. And so this book is written for all the rest of us, as much as it is for them, to say, look, there are ways in which we should be thinking about the conflicts we have with one another in different ways, that those can actually align with some other instincts we have about just outcomes, and that we don't need to kind of legalize and fetishize our rights conflicts.
So speaking of decision makers other than courts who influence politics, you're a co-chair of the Facebook Oversight Board, which yesterday issued a very significant decision in the question of whether or not Trump's indefinite ban, as instituted by Facebook after the events of January 6th, was appropriate. And I've seen it reported on in multiple places as a Solomonic decision, which I thought was sort of funny because you mentioned that that's a term that comes up in this book as well. But I'm wondering if, do you see the approach that the board took in that case, or that it's taken in some of the other cases? The board is, for those of you who don't know, brand new. This was case number 10 that they decided. Are there parallels between the approach you want US courts to take in this book in terms of balancing and proportionality and the decisions that are coming out of the oversight board?
Yes, I think I would say yes. And I'll step away a little bit from the Trump case itself, which I think is emblematic of an approach that the board takes in these cases, which is highly contextual. and necessarily contextual, because we're in a sort of uncharted space where it's not really obvious exactly what the applicable, I'll put legal in quotes because there's even dispute about whether it is a legal regime, but um, how the legal regime should apply. So here are some of the contextual factors, right? Facebook is a private company. It is not a public company. I mean, well, it is a public company, but it's not a public actor. And so the First Amendment doesn't apply. International human rights law doesn't apply directly to the behavior of Facebook. But Facebook has committed itself to complying with international human rights norms. But what does that mean? International human rights norms don't apply to private companies, and so does that mean treat Facebook as if it was a state? Treat Facebook as if it was a state doing what? As if it was a state engaging in first order regulation of its citizens, uh, treat it as if it was a state setting up a social media platform that competes with others. Those are very different situations. And so essentializing some set of rights and saying rights are rights, and free speech is the most paramount thing and can't be overcome in any way. But that certainly doesn't work in the regular US context, because there are so many variations on what it means to hold a speech right and what the other interests might be. But it absolutely doesn't work in this context because there are just so many interesting contextual variables that come into play. And likewise, it's not the case that, on the other side, private companies can do whatever they want. Well, no, I mean, there are private companies that are regulated in various ways. And it is also the case that this particular private company has committed to being regulated in a particular way, right? So, platitudes about either this is or isn't speech, or it's private or public, right? Those kinds of binaries that I criticize in the book. I think the context of the oversight board is a good sort of testing ground for that. And I think in general, the board has applied international human rights law, and international human rights law itself uses principles of proportionality, and is generally speaking non-categorical about the way it thinks about rights. It understands that rights are inherently limited, but that there has to be some structure and some process in working through what those limits are. And so I think that generally speaking, what the oversight board has done has been pretty consistent with, that doesn't mean that I think that everything is exactly the way the book would prescribe, but has been pretty consistent with the general thrust of the book.
So staying on this theme of online speech and how we regulate that, who gets to decide, I was wondering, does your approach, is there more room for direct government intervention in the way speech operates on these private platforms if we're taking more of a proportionality approach to rights? Right now, with the First Amendment being interpreted in a really maximalist way by courts, the thinking of a lot of people who study this is that it would be pretty much impossible for Congress to pass a law that would survive a constitutional challenge if it were trying to directly regulate speech on these platforms, because the First Amendment does not allow it. Does that remain the case under this more proportional approach that you're advocating for?
Well, so without necessarily weighing in on the premise that there's no way that the Congress could regulate exactly how, because I think this is a somewhat contested question. But what I would say is, I think you're probably right that the most conventional thinking would say that no, they have, Facebook has its own free speech rights as a company, and the directors of Facebook have their own free speech rights. And they can decide what kind of platform they want to be, and that's itself a protected First Amendment interest. And so the state can't direct them to can't it be compelled speech in some way if it said you must carry certain things or not others. Again, it's a contested view. But what I would say is that under the approach that the book would take, it's relevant, for example, what the speech environment is. If it were the case that Facebook was the only social media platform, as is true in some countries, that's relevant, right, to whether regulation of Facebook qualifies in some meaningful way as um, a free speech problem, right? Because Facebook then becomes the what Facebook does for its users. But if Facebook's the only platform, and for, let's say, and this gets you back into the sort of public utility model, right? If Facebook, had some natural monopoly that essentially prevented others from adopting a social media platform, and then imposed draconian rules on who can speak and how they can speak and so forth, I would think that a legal regime that is committed to the kinds of proportionality principles that I celebrate would want to know that fact, right? That would be an important fact. And it wouldn't be enough to say it's a private company. And that's in fact how how what are called horizontal effects or state action doctrine works in a number of countries, including much of Latin America, is that the questions that are asked are questions about power rather than questions about one's status as public or private, because that's sort of too that's a kind of quaint framework, right? Public and private are blended in lots of ways, especially when it comes to companies that avail themselves of various forms of monopoly power. So again, not to weigh in necessarily on, I mean, I will say I don't think it's the case that Facebook is a monopoly in the meaning of the exclusive, social media platform, right? But again, those kinds of questions would become relevant, and I think they should be relevant when you think about free expression.
That's interesting. Okay, I think we have time for one more question, so I'm going to draw from the audience pool. This is from Anonymous. Do you think a more fact-sensitive analysis will take away the advantages of traditional judicial review formulas in terms of prediction and legal certainty?
Well, so I'll say for one thing, I think that is the right question to ask. And if the answer to that question was it leads to chaos, then I would rethink it, because I think chaos is I think that's negative. I won't say it's the worst thing, but I think it's negative. The second thing I'll say is the US is the outlier here. The rest of the world behaves more or less along the lines that I'm suggesting, and there is not legal chaos in much of the world. There is in some places, and I think Brazil is an example of proportionality going bad, so it can go bad, right? But it can go good, right? Canada, I think, is a good example of that, where there's another system that has an apex constitutional court with really decentralized constitutional jurisdiction, and everyone, all the courts can make constitutional rulings, and yet there's no chaos, right? Courts work it out. They sort of figure out. What I'm suggesting is not every case is anew, right? It's to say, what are the kinds of questions we ask? So you develop a common law around government purposes. You develop a common law around costs. You develop a common law around alternatives, right? Rather than developing a common law around like comma placement, which has nothing to do with justice, right? So that's the point. So you can maintain a system of precedent. But the third thing I'll say on this point about legal chaos and legal uncertainty is, I think legal uncertainty to some degree is okay, and not just okay, but to be celebrated, and to be celebrated in particular in the context of rights, because part of what keeps us invested in the constitutional system is the belief that the Constitution sees us, recognizes us, that we're part of the polity that this Constitution governs. And in the rights arena, you can do I think the biggest danger is what Robert Cover, the great legal scholar, called juris pathos, which is legal decisions that make it seem as though communities that are marginalized, that the law doesn't necessarily recognize, are just permanently on the outs, right? That their position can never win, that the law just is what it is, and it's not going to change unless you get the power to, you get political power to change it, is not a good way to keep people invested in the constitutional system. And a little bit of uncertainty, a little bit of, if the facts are different here, maybe I might win, rather than I can only win if my guy gets on the court, right? Is a much, I think, a much healthier way of a pluralistic democracy proceeding. It needs some play in the joints, because it's not just a single normative entity, right? It's got value pluralism, and that value pluralism has to thrive. It can't just be killed off by court decisions. Again, that's not to say that there should be chaos, right? But it's to say that it's okay if we don't know certain things about rights. That's different. That might be different in the structural context, where we need to know sort of what the rules are, what institutions have what kinds of power, right? But I don't want to. This could be a much bigger conversation, right? But I don't want. I want to not fetishize predictability within a complex legal system.
I think that's a great point. The benefits of legal uncertainty in keeping people invested in the system. Well, we've run out of time way before we ran out of things to talk about. Thank you so much for being here. Congratulations on the excellent book. And thank you to all of the audience members for joining us.
Thank you.